Yesterday, criminal defense hero Don Hammond and I had a power lunch in Long Beach at an outdoor cafe. Everybody properly masked, social distance, everything was kosher, food was great. And we were talking about a libel lawsuit against Joy Reid. And we were kicking around some thoughts about that and how it seems to be a very significant case because it could have some far-reaching implications beyond Joy Reid. And my favorite criminal defense hero said there's one guy who's perfect for this, and that would be constitutional scholar and appellate law guru Jeff Lewis. So we got him. Thanks for joining us, Jeff. How you doing?
Great. Thanks for having me.
So I don't know. I'm just a layman. I kind of pretend I know what the hell I'm talking about. But Don's a real lawyer, and we both seem to think this might be a significant decision. Just briefly, it's about Joy Reid having at first retweeted something that wasn't very complimentary about a woman who attended a city council meeting, and it accused this woman of acting in a racist, obnoxious way, yelling stuff at a young guy, and apparently she didn't really do this. And then at first it was just a retweet of what somebody else had tweeted. And then a couple of days later, or a little bit after that, she tweeted again, this time adding some of her own words. And I think actually this was on Instagram. And then there was a third time where she did it again, also adding her own words. And an image of the famous image, iconic image of the angry white woman screaming at one of the Little Rock Nine students when they were escorted in. And so this case involves several aspects of your expertise, Jeff. You specialize in anti-SLAPP suits, defamation, First Amendment issues, and you're an appellate expert as well, and all that is involved in this case. So what do you make of this opinion?
Well, this opinion has three significant aspects. First, you had a federal court in New York declining to apply California's anti-SLAPP law, finding that anti-SLAPP law is procedural in nature and therefore federal law, not state law, would apply. That was fairly significant. And then you have the public figure issue, where the court went through and decided whether or not the plaintiff was or was not a public figure, and came down on the side of the plaintiff not being a public figure, which is significant in terms of the burden of proof. And then, so those are the two biggest issues of the case.
Right. So I think some of our audience is made up of attorneys, and it's probably mostly laymen. So let's try to make this digestible for the average person. There's several issues going on here. So my understanding is there's two categories of a public figure. One is somebody who's an all-purpose public figure, meaning you're a superstar, everybody knows who you are. And then there's a limited purpose public figure. Could you explain the difference?
Well, the significance of the difference is if you're a public figure, whether all-purpose or limited, there are heightened pleading and proof standards to get to a jury trial. You have to prove actual malice or reckless disregard of the truth. So it's a significant difference in a defamation case when someone has been categorized that way. And this court went through the factors and found that the plaintiff was not an all-purpose public figure. No controversy about that, but also was not a limited public figure, mostly because she did not regularly and purposefully inject herself into the media. She's not somebody you would find on the evening talk shows on a regular or intentional basis.
Right. So the significance of that is it's easier to get rid of the lawsuit if it's for somebody who's a public figure or a limited purpose public figure. I guess part of the reasoning is that they have the ability to counter the accusation, to restore their reputation, whereas somebody who is just an ordinary schmo doesn't have that ability. So do you agree that she is not a limited purpose public figure? She's just an ordinary schmo?
I actually do agree with the court's analysis here that she should not have been labeled a limited purpose public figure. The analysis that the Court of Appeal did was spot on, I thought.
Okay.
I think we should actually start a little further back than that. And can you help us understand this concept of an anti-SLAPP lawsuit and what that actually means?
Sure. Yeah. So California and a number of other states have anti-SLAPP laws, which provide a procedural device for a defendant to exit a case very quickly. In California, within the first 60 days, a defendant can file a motion. When you file that motion, all discovery is stayed, and the plaintiff must then file a response proving up the probability of prevailing on the case. They have to all of a sudden, without the benefit of discovery or time and the normal procedures in a normal case, they have to prove up all the minimum elements of the case. And if they can't, the case is not only thrown out, but the plaintiff has to pay the defendant's attorney's fees, which could be anywhere between $50,000 and $50,000, $500,000. It's a big sum. So it's a significant procedure that's available for defendants in California.
So a big part of the law is striking a balance between competing considerations. On one side of it is, well, we don't want people to have frivolous lawsuits and impose burdens on people and take up the courts too much. But on the other hand, we don't want people who have legitimate lawsuits to be deprived of the opportunity for justice. Do you think the balance has been struck in the right way? And what's going on now with the possibility of adjusting how that is struck?
I think in California, the process is balanced correctly because, first of all, anti-SLAPPs can't be filed in every case. It's an anti-SLAPP motion to dismiss can only be filed in those cases where you show that the case is filed based on someone exercising their First Amendment rights. So if someone sues Jeff Norman for things he says on his podcast, that's an exercise of your First Amendment right. You'd be able to file an anti-SLAPP motion. It doesn't apply to car accidents, lemon law cases, or the vast majority of cases that are filed in California.
So there's a conflict, at least as was mentioned in this opinion that we're discussing, between the federal rules of procedure and some of these state anti-SLAPP statutes like California. And it seems to hinge on the distinction between probable and plausible. In California, there's a burden on the plaintiff to prove that it's probable that he or she will prevail. And on the federal level, it's plausible, which means it's harder to get rid of the suit. So you don't like
right.
Well, you represent people on both sides, correct? When as it regards anti-SLAPP disputes?
Most of the time I represent defendants sued for defamation. So I'm usually the party that's filed an anti-SLAPP motion, although on occasion I will represent a plaintiff.
Okay. So I think I have two different questions here. One is, which is more reasonable, the plausible or the probable? And the other is, does it make sense, or do you agree with this conflict that it's a problem, there's a conflict, as this court just stated?
I actually, even though I am very pro-defendant and very pro-anti-SLAPP motion, I actually agree with the outcome of this decision. I think there is a clear conflict between the procedural aspects of an anti-SLAPP motion and the federal court procedure. And federal court trumps state law, and there should be a federal anti-SLAPP law. A federal anti-SLAPP law. Until there is, this court rightly refused to consider an anti-SLAPP.
Right. And thank you for bringing that up, Don. You're right. We should have started with that. SLAPP stands for Strategic Lawsuits Against Public Participation, which screams to me as if they came up with the acronym first and then tried to just make it fit anyway. That is some really cumbersome wording. Strategic lawsuits against public participation. I think they're talking about speech. Is that what they mean by public participation?
It's not always speech. I've had cases involving petitioning the government for redress. So, for example, I once represented somebody who was sued for speaking their mind at a public meeting about a land use development. They were sued, and we got the case dismissed on an anti-SLAPP. So it's a little broader than speech. It's petitioning government as well.
All right, so why don't we take a look at what Joy Reid said. Let me see if we can find the first one. The Joy Reid. Okay, this is the first retweet. And this Joy Reid is not accused of defamation here, but this is how it started. You are going to be the first deported and dirty Mexican, were some of the things they yelled at this 14-year-old. He was defending immigrants at a rally and was shouted down. Spread this far and wide. This woman needs to be put on blast. And then the second one is he showed up. I guess what I did was I put the second Instagram post together with this one. He showed up to a rally to defend immigrants. She showed up too in her MAGA hat and screamed, "You are going to be the first deported, dirty Mexican." He is 14 years old. She is an adult. Make the picture black and white, and it could be the 1950s and the desegregation of a school. Hate is real, y'all. It hasn't even really gone away. So I think the issue here is in the first retweet, it was just vague about things people said at this city council meeting, whereas now Joy Reid is attributing the words to the woman whose name is Ms. La Liberté, I believe is her name. That's the key distinction, right?
Correct. That's why ultimately this case was sent back down, and the case is going to proceed.
Right. And then here's the other one. This is not the actual screenshot of it, but the text I took from the court opinion, and then it's a famous picture, so I found that and just put these two things together. It was inevitable. This is Joy Reid again, her words now. It was inevitable that this juxtaposition would be made. It's also easy to look at old black and white photos and think, I can't believe that person screaming at a child with their face twisted in rage is real. But it's supposed to be, but every one of them were. History sometimes repeats, and it is full of rage. Hat tip to so-and-so. So here she's not explicitly making an assertion of fact. It's an insinuation. Can an insinuation be libelous?
Sure, absolutely. Sometimes the most serious things are insinuated. If I have a former client and the client is known publicly to be my client, and that client calls me a thief and a liar, there's an insinuation there that that client possesses facts about me, about how I represented that client. And yeah, implied and insinuated defamation is possible.
Right. So Joy Reid is arguing that what she said is not materially different from what was originally said. And that brings up the Communications Decency Act, which immunizes social media platforms, and it also immunizes people who retweet things. And the court said, well, no, you are the author of this, Joy Reid. So do you think her argument has any merit?
I think the trial court and the Court of Appeal got it right there. That's the least controversial part of this decision. Twitter can claim immunity under the Communications Decency Act in Section 230. But somebody who tweets and adds to a tweet and adds their own spin to it cannot claim such immunity.
Back in 2018, Trump, I think this came from a press conference, I forget exactly what, but he said, we are going to take a strong look at our country's libel laws so that when somebody says something that is false and defamatory about someone, that person will have meaningful recourse in our courts. Our current libel laws are a sham and a disgrace and do not represent American values or American fairness. So despite the likelihood that Trump is motivated by how it affects him, I think it's a valid point, because anybody who goes into the supermarkets and sees the tabloids and all the lies they make up all the time, you can't help but feel a little bit sorry for these famous people. It seems like things are a little bit out of whack, and the media can get away with almost anything as long as it's a famous person. What do you guys think? Either one.
I think there's a little bit of daylight between the two Jeffs here.
Mhm.
I think, especially when it comes to Section 230 of the Communications Decency Act, that it is important to give Facebook and Twitter immunity so that they can continue to do what they do. I do feel like the Section 230 needs to be amended. There is a problem with anonymous commentators who post things anonymously on the internet. They take a hit at somebody, and if that person can't find out who it was and it's demonstrably false, they don't really have a remedy to go after Twitter or Facebook. And that's unfair. And I would like to see Section 230 amended to give plaintiffs dealing with anonymous speech a chance of a level playing field.
So they could put in at least a subpoena power to be able to force Twitter or Facebook or a platform to reveal who that anonymous poster was. Would that solve the problem?
Not always, not always. And if that person is using VPNs or other privacy software to hide where they logged in from, that plaintiff is left without a remedy, and that comment is left up on the internet forever.
Sure. So what obligation is there, if any, of a platform to verify an identity of a user? I know, like when I created my Facebook account, I put in my name, and like they have my phone number, they have my email address. I mean, they know who I am, but I guess I could create a false profile with all false information and it would be just fine, huh?
That's the thing. People have disposable or throwaway accounts that they use just for purposes of a drive-by online attack.
You know, I have run into that with Instagram. They call them Finsta accounts, right? People's fake Instagrams that they share with different people rather than their main account. I've seen that in cases when I'm researching people who are involved in my cases. So that's interesting.
If I could just get back to what Trump said back in 2018, I don't think he was necessarily referring to the Communications Decency Act, and whether or not he was, I'm not necessarily referring to that when I talk about, the supermarket tabloids and in general how these big media organizations seem to be able to get away with almost anything just because the person is famous. Is there not some, at least, I mean, I don't know that there's a solution. It might be that the lines are already drawn in the best place they can, but I feel like it's legitimate to at least look at that issue to see if things can be improved so that famous people aren't vulnerable.
Well, I certainly think that media outlets should not be able to just make things up out of whole cloth that are defamatory and then just go ahead and publish it. I mean, there should be some remedy for that. It's a question of what the remedy is. And, where the line has been attempted to be drawn is that if it's a famous person, you've got to show actual malice, that the publication for some reason is trying to destroy this person. And I think that, maybe we've drawn that line, too broadly to allow that. What do you think, Jeff?
I don't think it has been drawn too broadly, honestly. But, one policy choice the states could make is to adopt a loser pays scenario, that when a plaintiff prevails in a big defamation case and has to spend a lot of money to get there, that the defendant not only has to pay damages, but all the attorney's fees. Of course, that would also apply when a plaintiff files and loses. And you might have a chilling effect that celebrities and ordinary folks might be less willing to go to court and risk a fee award if they know at the end of the process there's going to be a big fee bill.
So the significance of malice is that it relates to the standard, and the standard differs based on whether or not it's a famous person. So when it's a famous person, you have to prove malice, but when it's an ordinary person, you have to only prove negligence. Could you explain a little bit on what that distinction is and how it's determined?
Well, it's the difference between knew or should have known. In the case of malice, you need to either know that what you're saying is false or have reckless disregard for whether it's true. That's on the malice side. And in terms of negligence, you just didn't try hard enough to verify your facts. You didn't look to see whether or not what you were saying was true. That's not quite to the level of intentional action.
So does it look to you as though Joy Reid is guilty of negligence in this matter?
At this point, it's just on the pleadings that I saw referenced in the two decisions that I reviewed. I do not see this case being disposed of prior to trial. This is a case that I think is going to go to trial. There's enough triable issues of fact on intention and negligence to have it go all the way.
All right, that's a cautious answer. Do you want to go out on a limb and say whether or not you think she might be guilty of negligence?
It's cautious only because I haven't seen the evidence.
Okay, fair enough.
Lawyers are hesitant to judge a case without actually seeing all the evidence and understanding the issues. And we don't want to. We're not on the jury, and as we see, many times in cases that are high publicity, a jury comes back with a different decision than what the public thinks, because the things that are made available to the jury are different than what's made available to the public.
Okay, fair enough. So this story got a lot of play in the Hollywood Reporter yesterday, and I know that a bunch of media organizations submitted briefs. Can you say a little bit about the significance here? And, is this a big deal? Is this a game changer, so to speak, or at least potentially?
Well, yes and no. With respect to the SLAPP law, it's absolutely a game changer insofar as the tide might be turning and maybe the Supreme Court might actually take up this issue of whether or not you can apply the various state SLAPP laws in a federal court. And if the Supreme Court were to rule and agree with what the New York court did here, then all of a sudden federal court would be a welcome place for plaintiffs to file defamation actions. So that is significant. It'll be interesting to see if Joy or MSNBC takes the matter up to the California Supreme Court. Excuse me, the United States Supreme Court.
Does a plaintiff and a plaintiff's attorneys have some options when they're starting a lawsuit about where to file?
Of course, yeah. You can. There's lots of games that could be played in terms of deciding where to sue, and that was even mentioned in the decision that was issued in New York last week or this week. Whether the fact that forum shopping might occur is possible, but it was not a factor to be driving the outcome of this case. The court basically ruled.
Right.
I mean, in this case, there's diversity jurisdiction, right? We have a California plaintiff with a New York defendant, and that's how we got to federal court?
Correct. But I don't know if it was originally filed in federal court, if it was originally filed in state court and then removed.
Okay.
All right. So you mentioned this is significant with respect to the anti-SLAPP issue. What about the public figure aspect of it? Should this be taken as a warning? Maybe also considered in connection with other cases like the kid from Covington, Kentucky, who sued after CNN and a couple of other media organizations claimed he was, threatening folks and really just standing there smiling.
Here's what I'll say about that. I didn't view the court's analysis and conclusions as controversial. It was pretty straightforward application of the limited public figure. It's more of a reminder than breaking new law here in terms of a limited public figure status.
Right. And it's hard to say, I guess, what kind of an effect these reminders have. I'm just suggesting when you have multiple decisions, or two anyway, I'm not sure if there were any others, and I don't know who pays damages too. Like, do you guys have any thoughts about that? If somebody, in Joy Reid's position, if this costs money, is MSNBC going to cover it for her, or is she going to have to pay for it?
Or is there insurance to cover it? Those are good questions. It comes down to when she's tweeting, is she tweeting in the course and scope of her employment by MSNBC, or is she doing it personally? And is it within the terms of any insurance policy? Those are all really good questions.
Yeah, it's certainly possible to insure for that. And MSNBC could have, basically libel insurance that would be covering her here. And then really the question is, was it in the course and scope? And is it part of her job to be doing commentary like this? Certainly it promotes her show for her to build an audience and distribute commentary like this from what appears to be her personal social media accounts. So it's a question of whether that really is in the course and scope of her duties, or whether this is something she does sort of on the side for fun. Certainly it bolsters her show. So there's an argument to be made there that her employer should pick up the tab. And that may be the subject of a separate lawsuit of her going after her employer to get them to cover if that becomes an issue.
Yeah, and there's a difference between the duty to defend and the duty to cover. Maybe the insurance company will initially defend, provide lawyers, but at the end of the day, if she's found liable, they won't write the check.
Right. So, I mean, on the surface, I can see why media organizations would be paying attention to this case. But since I am just a moronic layman, I'm not quite sure what their angle was on this. And I don't even necessarily assume that you read the briefs, but maybe you can make an educated guess what the media organizations were arguing when they submitted all these briefs.
Oh, well, media defendants love the ability to get out of a lawsuit very quickly and have the plaintiffs pay their attorney's fees. So at the end of the lawsuit, they're 100% whole. And New York is a big media market. I could absolutely see media asking the court to weigh in on the side of application of anti-SLAPP laws. But I think in the absence of a federal anti-SLAPP statute, the media defendants were wrong here. There was no basis to apply anti-SLAPP law here.
Well, yeah, I'm wondering what the reasoning might have been. I think, I can assume what outcome they wanted, but can you imagine what they might have even been arguing to try to get the outcome they wanted?
Well, I can think of two categories of arguments. One is there are circuits that have applied the anti-SLAPP law, including the Ninth Circuit, which governs California. And two, there was a smattering of cases that suggested that the New York federal appellate system had already ruled on this question, and that therefore, instead of deciding that anti-SLAPP doesn't apply, they should extend these prior rulings and confirm that anti-SLAPP can be heard in a New York federal court.
Okay. Do you think we covered it pretty thoroughly? Anything else we should say about this topic before we?
I'm having bar exam prep flashbacks with these libel and different standards of negligence and malice and public figures, and I'm probably going to start twitching in a moment because that memory of studying for the bar exam and having to learn all that stuff is a long forgotten memory that I'm happy to be out of. And I'm glad that there are people like Jeff Lewis who continue to practice in that area and will take these cases because I don't want to litigate in this area.
I do enjoy the First Amendment work.
Good. Well, I appreciate it as well. And if we ask you nicely in the future, is a chance we could lure you back again, Jeff?
Sure, you bet. I'd love to.
Okay, great. All right, guys, thanks so much and have a good one. And we'll see you soon.
Bye.
Thank you.